Folks, a lot is happening in Ghana. The news is trickling in every day at torrential speed, such that when you close your eyes, the news will go over your head. It will just keep you will not understand what is going on. There's, in fact, information overload. But because just yesterday, the Supreme Court ruled that the political parties should disband, or they should stop this delegate system and allow everybody who has registered in their register should vote. Just as we are trying to analyze and evaluate the issues thereof, a new issue has come. That is Sedina Tamakloe, who was recently repatriated from the Americas to Ghana to serve a sentence, has been acquitted by the Court of Appeal because she has lodged an appeal at the Court of Appeal some 2 years ago. I mean, 2024, as soon as she was sentenced to a 10-year imprisonment. But what happened? The issues are scathing, such that on face value, it doesn't make sense that the Court of Appeal has acquitted her, has let her off the hook. But you would realize that normally lawyers, they don't go to the market with sentiment and feelings. Unlike we, the lay people, once the issue comes, we are disparaged, we are raging all over town, and so we are of the view that the optics are not okay for the government and all of that, of course, because she is part of the ruling government. But when you look at the issues clearly, you realize that the 9 grounds on which they took to the court have some merits. No, I have questions to ask, but on the face of the ruling, the judgment, when you look at the reasoning behind it, you realize that the case has merits. For you to escape 78 charges leveled against you, at the Court of Appeal, something is wrong, and all heads must roll. By this time, the people who prosecuted, the prosecution team, should be evaluating the work that they did. In 2017, when the MPP government took charge of the administration of the country, of course, the SY government they have to be accountable. They have to be taken through the rigors of accountability to ascertain whether they were good stewards or otherwise. So the CEO of MASLOC, who was in charge of disbursing money to small businesses and medium enterprises to augment their businesses and to boost their wares, had an issue. And what are we talking about? They are talking about defective charges. Because in one instance, the prosecution, who is now the respondent, is saying that they didn't do something. Let's say a case in point. When the Kantamanto fire out broke, the MASLOC CEO or the MASLOC entity went to disburse some money to help the people. But the prosecution is saying that they didn't do it just because there are some appropriations. I admit that there are some differences that have not been retired, and of course, according to the witnesses, the 7 witnesses that were called to be the prosecution witness. But that is not enough to say that it didn't happen. The prosecution could have said that they didn't do it well, or maybe they may have misquoted the figures. But if you just say they didn't do it, and the appellant is also at the court saying that we did it, then you realize that the two issues are at variance. And that is how come they are being acquitted right now. It doesn't make sense. It doesn't make sense. Okay, another case in point. She went to buy about 350 cars, of which the market value, the going price, was at variance with how much they bought it. But you would ask, as a layperson, for a government entity who was buying so much cars at a time, definitely there will be a rebate. There will be some reduction of a sort. But they rather went to buy so much, and of course, under a sole procurement agreement, even without authorization from the Minister of Finance. Or no, from the minister, from the procurement agency. So you realize that these are all infractions against the laid down procedures and rules. So if the case were brought against her very well, she must be convicted. She should have been convicted. But the respondents were also of the view that, first of all, this lady in case, this Sedina Attionu, should not even be granted audience at the courts, because she has always been a fugitive. She has always been on the go. To start with, even the sentence that was given her at the first time, she hasn't served it. She has not. She should have started serving it, and then she will be eligible to bring the case to the court. But the court is also saying that, or the appellant counsel is saying that, no, coming to court is as of right. Okay, it's already in the lay down rules that when a case goes against you as a citizen, or like, you have the right to appeal. So you don't necessarily need the permission of the court before you appeal the case. So to say that she has been out of the jurisdiction, she has not served she has been out of the jurisdiction, has not served her sentence, is tantamount to an accused who has refused to talk. You have a right to remain silent. So likewise, if she's out of the jurisdiction, it is tantamount. It cancels out. It's just like she's in town and still has refused not to talk. So there is no case to that, and that is what the court has said. The court also came to the conclusion that for the prosecution to avail weak charges against the woman, a case in point, they are saying she didn't do something. For instance, the letter that she wrote to the microfinance for advancing 500,000 at an interest of 24%. The prosecution says the accused has not, or they were pushing the burden of proof on the accused to prove, even as against the fact that she is saying that she didn't write that letter. She wrote the letter, her signature was there, but because she is saying that she has not written the letter, the burden of proof laid with the prosecution to prove a point. So, fact that you didn't do all of these things, but the prosecution is also saying that on the eye test on the charges, they brought witnesses, they brought the letters, and were able to also articulate their charges. So by doing those things, they have brought their case to bear. By doing those things, they have shifted the burden of proof onto the accused to respond to show that she is not. So the court were of the view that, no, that's a weak case that was brought against her. So you realize that the court didn't even do much. I will give it up for the counsel for the accused, who is now acquitted. But the silver lining really is the fact that if you read the judgment, you realize that when the Attorney General goes to the Supreme Court, when they bring an appeal against the woman, they can convict her. They can bring some, there can be a balance there, because okay, they didn't bring the right case, they didn't bring the right charges, the 78 charges that they couldn't even secure one conviction out of all that. Okay, where is the money? Where is the money? So somebody has appropriated the money. So it's just about maybe looking at the gaps, the loopholes, and what went wrong, and then articulating their charges well, going to the courts, and then maybe we can secure conviction against, because I am of the masses, the foot soldiers, the people on the ground who feels like the optics are not good. Because how is it that your party member misappropriates, or let's say misadministers her position as the CEO of the then MASLOC, and then when she was convicted, even against, even if her even if the conviction was brought against her without justice, or she didn't get a right ruling at all, you don't leave town, you abscond, you become a fugitive, you're on the run, and then your government comes in, then suddenly you walk in, and then you get acquittal. Why didn't you come before? You even begin to question the why did we even bring her in? Why did we repatriate her with the taxpayers' money only to come and get conviction? I don't think it's okay. Even if the technicalities, the law says she's been acquitted, I do not think that this will augur well for the NDC party. Yes, they have to find a way to either retrieve the money, find a way to convict her, even if it is 2 years, 3 years, because definitely looking at the issues, you realize that it may not necessarily go that high. The trial judge at the High Court convicted her on all charges. She and her operation manager. She was convicted on all charges, all the 78: willful causing of financial loss, conspiracy, stealing, and conspiracy to steal. All of these were brought against her. So if at one point 78 charges were brought against her, at another point all the 78 charges have been quashed, then it beggars belief. We really should look into the law. The Attorney General Department should sit, the government should sit, they should find a way to convict the lady, unless she hasn't done anything. Yes, the law should take its course and justice should be served. Yes.